Yeah, thank you for staying with us. It's still TMI, and we're looking at the roles of political party delegates, influence, and their limitations. And that brought us to a point where we were to speak with the custodian, looking at the aspect of the Constitution, 84 subsection 14, that specifically, streamlined the persons in question that is responsible or that will be seen as having the ability to, demand for actions as regards the invalidation of a primary or the party's candidate. But again, the 378 candidate political party delegates that went to the court weren't about nullification of the candidate of the party, but were about their unlawful exclusion from the process. Now, I asked you that question. At what point can it be seen? Because I asked you that before, but let me ask you again. At what point can it be seen that delegates who are lawfully seen as delegates will be excluded from a primary?
At what point?
Looking at the case in point of your party, of the PDP.
Like I said from the outset, the issue of delegates, you quoted a portion of the Electoral Act.
Mm-hmm.
And there are multiple judgments. I'm not a lawyer, there's a term I'm trying to get for it. The Supreme Court has spoken on it separately. I read the number of articles on such a note. So it's very clear from the standpoint of the law, as put forth, who could challenge processes as they pertain to primaries.
Okay.
Very, very clear. But of course, that won't stop anybody from seeking redress where he or she feels dissatisfied with any process that was carried out.
Okay, the challenge here again is that at the point where we expected that the counsels and of course the lawyers to know the wordings and craftings of the court, which are not spiritual, we started hearing erroneous impressions about a judgment that was misconstrued as being said. Now, what do you think of this different argument that came with the judgment of that was delivered by Enyang Ekwa at the Federal High Court?
I read that judgment severally. Fortunately, the last 2 pages contains the specifics as to the judgment given based on relief sought by the plaintiffs. And to the best of my knowledge, there are 3 paragraphs specifically. Without being in the pool of the learned, if somebody seeks relief in the court of law and the court passes judgment or grants specific relief, you benefit within the purview of that judgment or the relief granted by the court and nothing more. So when I hear different schools of thought, people saying this, that, there was disqualification, there was this, there was that, I had to attempt to read the piece over and over again to see if the English was different or is different from what we are taught in the use of English basically. The concept of benefits separate from the judgment has given is strange. If a court gives you something, you don't take beyond it because it is specified within the purview of the judgment given. So, but you hear people interpreting that it's a case of inference. Okay, that these guys were supposed to participate in primaries, going by the judgment given. The primaries took place over 4 months ago, on the 22nd of February. There is no verdict by the court iterating specific consequences because the relief sought were the issues that the court addressed. So that's why I said there is nothing that comes up. From the outset, I've already registered my peculiar suspicion in terms of the
78 delegates.
They're actually 381.
381.
Because 3 of them filed the case, then they had 378 that they listed in their documents, BID 8A to 8L, as the case may be.
All right.
So that's where they listed the names of the others. And so, I registered my discontent just now from my common sense opinion that if that stuff were real, the National Working Committee In fact, not it would have gotten to them. The appeal panel would have just reversed the entire exercise.
Okay.
And so I have my conviction that it was simply an afterthought. And when I read through the judgment too, the second defendant's response to it was on that note, that the 3 guys who filed the case are delegates. I read the piece where that was affirmed. But that the other 378, they are not. So, and the second defendant.
What do you mean they are not?
I'm talking in the judgment. The second defendant is the party, is the PDP.
When you say the 378 are not, what do you mean?
They are not the delegates. So the party in
the
that
378 are not the political party delegates.
They are not.
What are they?
They are what they are. I'm talking about what the party said. The second defendant, as put forward by their lawyer, which the judge marked in his judgment. So it is documented, it's not subject to contestation.
Okay, but you know that there are different, arguments to it. Why a particular faction will be saying that they are not delegates, the other faction is saying they are.
Okay, now
so
if you come to
that's exactly where we are. There seem to be these issues where we have to situate a point, to closing the gap for us to have a healthy political party with that internal democracy that it should have.
I'm talking as an individual, not as a PDP person or a member of PDP.
All right.
Now, see the point we are highlighting. When you say the other faction, there's a history to this thing. Who conducted the Congress? Before the Congress, if the other faction, so-called, had the leeway that they claim to seem to have presently, would they have been protesting and complaining that they discontinued the process and they don't want to be part of it? Highlight that. Secondly, the other faction, like you mentioned,
okay,
by the verdict of court, over a year, almost 2 years ago presently, or thereabout, if no more, had already given validity to the leadership that is presently in the state, led by by Dr. Azegbeni. So, before the law, there's just one faction. The other side that is discontent, in quote, is not within the purview of the party any longer because they have lost out from the struggle as it went through the court of laws. That's why I put it to you that if they really had that reach, the issue would not have gotten to this point.
Okay.
I said something earlier.
Oh, okay, I'll come back to you.
The total number of delegates.
You've articulated a point. At the point where you said that, as is being said, the 378 were not really political party candidates. Delegates. Now, let's take your portion of argument from that perspective.
They should have been in Obe Stadium.
Okay, let's take your portion from that perspective.
What I feel is that before you become a delegate, there are power that governs the party that are legislated with the power to choose who becomes delegate. There is a process to it. And I think that before you are made a delegate of a political party, there should be a letter to that effect that Mr. F has been nominated to represent his ward. So the question would be that the people that call themselves delegates, what was their standing point to go to court? They must be able to have something to back up what makes them a delegate. Your delegate is not a naming ceremony. You cannot just call yourself a delegate of the party. There must be some things that qualifies you. There must be an appointment given to you that is backed up with a document that will be able to say Mr. F has been nominated to represent ward so as a delegate in the forthcoming primary, which will be signed by the party hierarchy that will give you power to be able to say you are a delegate. Those are questions we are going to ask those people that are delegates. What is it that qualifies you, that makes you know you are a delegate now? Or you say because I'm a member of a political party, that makes me automatically a delegate. Anybody called a delegate must be documented and appointed by the political party. Is that fact presented before the court that qualifies those people that call themselves delegates? If such exists with the needed signature, then which means there is a trouble. And if this kind of, like what is being said that, this number of persons are delegates, what qualifies them? How did they arrive there? Has the court confirmed if really they are delegates? Because if truly they are delegates with that bulk number, of what is supposed to be the total number of delegates, I don't think anybody will sweep them somewhere and go ahead and conduct something that you know that it will have. We have issues in Zamfara. We have issues in River State. We have issues that have to do with internal democracy in Bayelsa State. And at the end of the day, we saw that even what happened, everything went down by the pronouncement of the court. I think that the primary that was conducted, the delegates that were appointed by the eye of the law, the organs that conduct it, are they empowered by the law? If they are empowered by the law to conduct it, they have the power to choose who becomes delegate.
Okay.
And if there are issues that ensue between few hours to the election, delegates can be stopped. Okay. Delegates can be changed. Not that that is the style, but because the power that control any party dictates the issue of delegate is so, it's not an eternal something. It is just for a while. All right. So, and you needed people who will do your bidding. You can't make your enemy delegates. If you discover that there is going to be disloyalty, the powers that appointed delegates also have power for any reason to write and say for so reason 1, 2, 3, 4, 5, 6, 7 delegates, we have to drop them and we swap with another. They have the power by law to be able to do that.
When you say they have the power, are you talking about persons within the party or using the constitution of the party?
I'm talking about the constitution of the party empower.
Okay.
It's not every member of the party that can do, that can be nominated as delegate. It is the power that control the party that determines who become delegates.
All right.
We all know that, but we may not done the truth.
Okay.
But if I'm sitting down as a governor and I want to come the second time, I will not fold my hand and allow the party organ to bring out my enemy to become delegate if I'm coming for second time. So I must have my say as far as the delegate is concerned. And if I have issues with the loyalty of the delegate, even though if it is 48 hours to the primary, I can also make sure they are out of the system and there will be a letter to that effect. For so reason, we have to do some swap for emergency reasons. So,
all right, thank you. Thank you. Let's get your comment, Matthew Ederese, a legal practitioner. I believe by now we must be able to establish contact with you. Good morning once again, Matthew Ederese. Can you hear me? Good morning, Matthew.
Good morning, Mr. Phillips. Thanks for having me.
Thank you. All right, awesome.
I can hear you
now,
very clearly.
you've been following the conversation and what transpired in the courts and, of course, the spurious argument that came up or that followed that judgment of the Federal High Court as delivered by Inyang Ekwo. Now, we are looking at the Constitution, the section that spells out those who have the powers to approach the court to demand for either, suspension of the primaries or going forward in that regard. What do you say about the Constitution, like the section 84, subsection 14, that spells that out?
The issue they took to court was well spelled out in the judgment that was actually delivered. The content of that judgment is to the effect that those who were excluded unlawfully, those delegates that were excluded, should be given the opportunity to go back and participate in the process that is already done. I see that judgment itself as an equate judgment. It's an undecided decision. If you are saying people were unlawfully excluded and they ought to have participated in a process, and the process you are talking about has long been concluded, and you're asking them to be allowed to go back and participate in history, nobody goes back to history and be part of it. It is those who were part of the events that make the history. You don't go back into history and be an actor, a participant. I find that judgment very strange. A judgment of court should be a decision, a final decision, not an opinion as it appears in this case. Why will the judge not make a definite pronouncement as to consequence of the exclusion of the persons in question? If they were excluded, the judge ought to have gone further to give a consequential order that the entire process either becomes a nullity, if that is his position, If you feel the process was valid, then the question of asking them to go back and participate in the concluded process shouldn't even arise. It's an impossible, impossible expectation. What the judge should do, or that he did not do, was to make a definite pronouncement. A decision of a court should be conclusive, not left hanging the way it is left hanging and dangling now. What the judge have done is to leave everything within the realm of speculation. Both parties are now laying claim to victory. A judgment that gives victory to both parties is not a judgment. It's an indecision. There should be a clear winner and a clear loser in the court judgments. In this case, it is not clear who is the winner and who is the loser. It appears that the process still stands. And those who complained about being excluded were also given a victory that is not defined to go back and participate in the process that they can no longer start afresh. So it is strange to me what the court did.
It's of no consequence because you said they can't go back to history and correct it.
It's not possible. A decision, of course, should define clearly who the victor is and who the loser is. In this case, it is not defined. They left it hanging and dangling, making room for speculation and whatever. Different interpretation. Judgment, of course, should be self-interpreting.
Thank you so much, Matthew Edegese. We thank you for taking part in this. We actually would have loved it if we were not having technical hitches for us to ask you further questions, but we are pressed for time. Big thanks for taking the time to be part of this, and we wish you a beautiful day ahead of you. Well, in order to set the record straight, political party delegates are not appointed, but rather they are elected, like when you made mention of that, that they were appointed. But at no point can we say political party delegates are appointed.
You see, either you say they are elected or appointed, but I will tell you that every delegate are appointed, but you will use the word elected.
But that's your word. That's your word against the constitution of the political parties.
What I'm saying
because
is that
by what we have in the constitution, they are elected, not appointed.
But do you know that we have seen series of elections? So that's why I'm saying that there is no election that will ever throw up somebody that will work against the power and the organ of the party. Yes, it can only happen when somebody is not in charge. When you are not in charge, you can fold your hand and allow others to be elected that will now wound your intention.
When you're talking about that, it brings a whole lot of questions, but I think we'll be wrapping up in a few minutes. Because if you talk about delegates, they have the free rights to choose whatever aspirants they want to choose to make them candidates. So is there a big man behind that will want to hoodwink that process?
In every political party, there is a big man behind. Let's not rule that one out.
Okay, I give you 30 seconds to round off.
Now, there's a big man behind, because to every there's an intention by an individual. That there is an interest. Politics is about interest. That's why you see that few persons come together and show their interest and harmonize it together and make it a point. Then the masses follow it. Where have you seen that masses always choose their leader? It is only few people within the party that choose who becomes who. Then the masses will now be co-opted into it to start saying, okay, vote for this candidate.
Okay.
So to every party, you can't exempt any party from what I'm saying, because there is always somebody's mindset that will be that will form the opinion of the direction of individual. That does not rule out that people cannot throw up with interest good candidates.
Thank you, Bishop Austin Igbasa.
Mop up vote to be able to put the person.
Thank you, Bishop Austin Igbasa. Let's get to your closing remarks as regards your reactions to that, what was credited to Bishop Austin Igbasa.
Just my remark before the closing remarks. You got his great bishop's remarks before you edit.
I'm coming to you. I said, let's have your final remarks on this. That's what I mean.
Now, I still maintain the point aside from. Thank God for the views put forth by the learned Matthew Edegese. It's even when I spoke from this value of the layman, to a large extent, I tend to toe that line that he put forth on a more enlightened note. So I feel inspired. Now, that's on the side. When he talked about appointment just now, you could appreciate it from the standpoint of the Nigerian context. Because in such elections, it's not just about the constitution of the party. There are guidelines.
Okay.
So for these very primaries that took place, there were guidelines earmarked. So who earmarks or who details the guideline is the leadership of the party. And whether you like it or not, across party lines, I concur with him on that note. There is always the factor of those who hold sway and to a large extent steer the ship, whatever decision they so choose. Because the ideal the party stands for doesn't exist in isolation, but for those who lead it to ensure that it takes that part.
So what you're saying that delegates, political party delegates, by virtue of what we have in Nigeria, they don't have their minds, the minds of their own.
I didn't say so.
Okay. Or they are being influenced by others.
Everybody is influenced at one point or the other.
Okay.
That's the routine of life.
All right, thank you.
And so, but the concept
You have
of,
10 seconds?
You're intimidating me. The issue at stake, in my opinion, is as good as resolved.
All right.
Resolved in the sense that there are clear-cut cases that have proved, that's explained by the lawyers. I'm sure if you even give this lawyer more time, he would have told you very clearly.
All right, thank you.
He has been put forward by the Supreme Court in the past.
Big thanks, Frank Ehioson. And big thanks, Bishop Austin
Must
Igbasa.
this kind of judgment be appealed with what the learned man said?
Oh, well, yes, we'll be looking at that. And I believe basically. No.
No, just 10 seconds, please.
Okay.
From my little perusal of relevant documents,
Yeah.
I realized that the reason why the PDP opted to appeal is not because of the peculiarity of the case in terms of its purport, but it's because they want to ensure that they save themselves the advantages some people will take.
All right, thank you. Thank you, Frank Ehioson. Big thanks, Bishop Austin Igbasa.